We are having a conversation, so, okay.
Right, but John, under the law, there's fraudulent presumptions under canon law 3228 that say otherwise, and there's a lot of support what I'm saying. So that's why I say.
Before we even hear a word from the courtroom, let's set the stage, because what you're about to witness is not just another routine hearing. This is a textbook collision between sovereign citizen ideology and the unforgiving reality of the legal system. At the center of it all is Eric Martin, a self-proclaimed living man who insists the court has no authority over him, while simultaneously demanding that same court give him exactly what he wants. Across multiple hearings, we see a pattern unfold: rejection of jurisdiction, refusal to cooperate, and an unwavering belief that repeating internet-born legal theories will somehow override established law. But here's the twist. Each time he pushes back, the consequences don't disappear. They stack. Bonds increase. Patience runs out. And the court record grows longer. Pay close attention to how the judge, calm, measured, and unmistakably in control, handles these escalating claims. Watch how arguments that sound confident at first slowly unravel when tested against real statutes, real procedure, and real consequences. And most importantly, ask yourself this: at what point does defiance stop being a strategy and start becoming self-destruction? Because by the end of this video, one thing becomes painfully clear: ideology doesn't cancel accountability, and the courtroom is where that illusion goes to die.
Okay, in the matter of People versus Eric Martin. Mr. Martin, can you hear us?
Yes. Can I get the case number of the so-called case that never was given a copy of the ticket by the police officer, which he should have in violation of my due process right?
241388 SM.
241. What else?
38 SM.
38.
1388 SM.
24138 SM. Right?
Yeah, 2 weeks.
Okay. All right, thank you.
I do have in front of me a complaint charging with domestic violence violation of city code. It's misdemeanor. Oh, I see January 24th, January 10th. Okay, you pleading not guilty, Mr. Gazicki?
Yes, John James Gazicki. Mr. Martin expressed his right not to be represented by a court-appointed attorney. He wishes to represent himself.
Okay. Is that right, Mr. Martin?
Present myself, yeah.
Okay.
Because I don't want to give up my right to be one of the sovereign people, as the U.S. Supreme Court said I have right to be. So.
Okay. I'm going to let you do that. I don't care why. Have you talked to the prosecutor?
No, I have not.
I want you to get the prosecutor and have her talk to Mr. Martin, and let's see what we're going to do today.
Right, so I would like to talk to him about how the case should be dismissed based on there's no evidence.
A matter of People versus Eric Martin.
Okay, thank you.
Mr. Martin, can you hear us?
Yes, I hear you.
Okay, Mr. Prosecutor, want to put your appearance on record?
Hey, good morning, Your Honor. Or good afternoon, Your Honor. Omar Shah on behalf of the People, PA 6332.
Okay. You've had an opportunity to talk to Mr. Martin?
That is correct, Judge.
Been able to resolve this matter?
Judge, there is no resolution on this matter. I had an opportunity to speak with the defendant in this case. He wishes to have a jury trial or a bench trial. He just doesn't know which one he wants.
Okay, Mr. Martin, which one do you want? I'm going to set this over for a trial. You want a jury or a judge to hear it?
Well, I don't really want to answer that question. I don't want to be fraudulently presumed. I'm consenting to any of these proceedings. I'm not consenting to have my right against slavery violated by consenting to any proceedings. So that's why I kind of want to answer that question. But before I get to, as I notified the prosecutor, he should have dismissed the case due to lack of evidence. But I had one more thing I wanted to point out to the prosecutor. I forgot to mention to him. I want to mention to him now, and that is I want the police officer, Bardaway, who illegally arrested me. I want him charged for the legal arrest, which is assault and battery. And also Judge Shackelford, who did not give me a personal bond. I want arrested too for violating my right against kidnapping and allowing this unlawful incarceration of me, which I have a right to do. And if they refuse to do it, I'm also going to move for dismissal on the case because it's violating my right against equal protection, because I have the right to have charges brought against people who have committed crimes against me also.
This is the moment where the argument fully detaches from legal reality. What you're hearing isn't just a disagreement. It's an attempt to invert the justice system entirely, demanding that a police officer be arrested for making an arrest, accusing a judge of kidnapping for denying a personal bond, and insisting that the court must file criminal charges on demand or dismiss the case altogether. Here's the legal reality. Bond decisions are discretionary, based on risk factors like flight risk, prior behavior, and compliance, not entitlement. A personal recognizance bond is not a constitutional guarantee, and private citizens do not get to order arrests from the bench because they disagree with lawful outcomes. Notice how the judge doesn't match emotion with emotion. He simply moves the case forward. That's not avoidance, that's authority. And it highlights a critical point for viewers. Courts do not operate on consent, ideology, or threats of lawsuits. They operate on jurisdiction, procedure, and statute. So here's the question for you. When someone rejects every legal rule but still demands legal protection, who do you think the system is supposed to protect? The process or the performance?
Okay, based on that, I'm going to indicate that you want a jury trial. I'll set this matter over. I'll have the assignment clerk set a date. She'll send you a notification of the date for the jury trial. In the meantime, I'm going to continue your bond until that day. You go with the sheriff, he'll take care of you today.
Hold on, objection. I have a motion to make that I have a right to a personal bond.
You file that motion in writing, and I'll take a look at it.
I already did file it with
In the meantime, I want you to go with the sheriff, and he's going to take care of you.
Hold on, object. I have some. I already filed it with the court. I'm making that motion now. I'm making that demand actually now because it's a constitutional right to be innocent without guilty. All right, then I'll be taking your job. How about that? Because you violate my constitutional right, and I move to dismiss you off the case, disqualify you. Since you violate my due process right to a personal bond, then you showed your biasness, and you should not be in the case no more. I move to disqualify you. If you deny that motion, I request that you send it to the State Court Administrative Office. You're not supposed to continue my bond with monetary award. Shackelford illegally denied my personal bond, and you're not supposed to continue that illegal denial. I have a constitutional right to be presumed innocent, and that means the right to a personal bond. Article 3, Section 1, judges that violate the Constitution cannot hold office. But don't grant that motion if you want to, that demand. I'll be to get your job in a lawsuit. That's all I got to say. So you want to continue with that? Sound like they muted me, maybe. Well, these judges are going to find out. They're not above the Constitution.
This is case 231510, People of the City of Taylor versus Eric Martin.
Jeffrey Fanto, the court asked me to verify that Mr. Martin would be presenting himself without the assistance of attorney. That appears to be his position, Judge.
All right, so Mr. Martin, you are waiving the House Counsel?
Yes, so I'm not fraudulently assumed to be the defendant, a living man, not the legal fiction corporate entity defendant, which I couldn't possibly be. I don't due to canon law being, unfair. It's gonna, you guys fraudulently assume that if I take an attorney. So that's the unfairness why I can't accept attorney because of that.
Sure. All right, and you understand all of your constitutional rights?
I do my best to. I've been studying, practicing law 28 years.
All right. That's all right. So looks like this is ready to be set for a jury trial. Is that right?
Yeah, but I want a jury trial of my peers means of the sovereign people, not U.S. citizen slaves who most probably everyone of the jury probably say they are. So.
This exchange perfectly captures one of the most misunderstood phrases in criminal law: a jury of your peers. It does not mean people who share your worldview, your beliefs, or your ideology. It means ordinary citizens from the same community, selected through a neutral process designed to ensure fairness, not agreement. The irony here is striking. Claiming decades of legal study while missing such a foundational concept doesn't strengthen credibility, it destroys it. And the judge, again, handles this exactly as a judge should: firmly, calmly, and without indulging fantasy. What's really happening beneath the surface is important. The court is offering due process at every step: jury trial, notice, preparation time, while the defendant keeps rejecting the very mechanisms meant to protect him. That contradiction matters. So let me ask you, if someone refuses to accept how the system works, but still insists on using it to their advantage, should the court bend or hold the line? Because this moment tells us exactly which path the judge is choosing.
As the individual who determines questions of law, that's me, I will make sure that it is a jury of your peers. So, and I'll determine that. So, we will have this set, and then I'll mail out the date for the jury trial.
I believe there is a date set for next Tuesday for the jury trial in this matter.
All right, I see that.
I have objections. I can probably prepare for trial in this jail. I've been illegally denied my constitutional right to a personal bond, even though it's my constitutional right because it's part of my right to be innocent before guilty. It's been denied so far. I have no money to pay for a bond to get out of here. So that's especially why I also should be given a personal bond. And like I said, I can probably prepare for one in here. You know?
So you're in there for a different matter, because I set your bond at $100 personal before on this matter. So it's whatever's keeping you in jail isn't this case. So we'll see. I understand though that you do need to prepare for trial. I get that part. So we'll go ahead and adjourn the jury trial. When is your out date? With whatever you're doing there.
There is no out date. That's the thing. It's So is this about the moped case?
Yeah, this is driving on
Okay,
driving while your license is suspended.
I wasn't sure. Right, they got me legally confined right now in the domestic violence. No evidence at all. She lied, made a statement. So now
hold on, Mr. Martin, hold on. Even though this is a different court and that's not my case, you have the right to remain silent. Anything you say can be used against you. I just want to advise you of your Fifth Amendment right again. So I suggest not bringing up the other case. This case here is on the moped and the driving on a suspended license, or revoked license.
Okay.
So what I'm saying is you need time to prepare on that one. I don't know what the situation or status is of the domestic violence case, but you said that you're on bond. You haven't posted your bond on that case. Is that what you're saying?
Well, I'm not even sure. I think the judge said a monetary bond. I wasn't sure because she unprofessionally drew the thing away from, you want to call it this, the remote Zoom thing away from the door before I could read to hear. But it's not like she told the police officer $2,000. But I'm not even sure. I got no money to pay a bond, no way, even if it's $1. So
I am allowed. I don't have nowhere else to live. That's my house. I'm allowed there. You ordered that to believe. That violates my due process.
All right. He has a $2,000 cash bond with a GPS tether.
Yes,
and he's not to
my right to a personal bond.
He's not to appear at
innocent without guilty.
He cannot come to 9074 Clipper or be in contact with Crystal Martin.
So, right, because they illegally deny my personal bond, this is why I'm still in here. So, but yeah. So,
all right. So what I'll do is, I don't know when that case is next. The next day is it's a state case. Ms. Manarino, you don't have that case, right?
I don't
so it must be a
know.
state. All right, and so it must be a state case, which means it's on a Monday. So that's probably going to be resolved within a month. So let me go ahead and set this for jury trial No, there will be no need to set it for a settlement conference before that. But
Well,
let's get a date.
I won't catch up. I was going to object before you guys don't give me a chance to talk. I objected like it should be. I moved that to be stayed. This moped case till I get out of prison. I mean, till I get out of jail here. I can prepare myself. I can't probably prepare myself.
Right, that's right. Listen,
Ask some of my legal authorities to
Mr.
argue nothing.
It's being set for a jury trial.
The other one is? Okay, so when is that one?
They didn't set it.
Okay. All right, so I'm gonna set it for a jury trial, but if you're still in jail at that time, then I'll just adjourn it again so that you can prepare. I'm not worried about that. So, I mean, but I can't do anything about your other case is what I'm saying. So I'm looking at, as far as the date right now, I just want to put a date on the books so that we know that you have an idea. I mean, if you get out tomorrow, then you'll know and what your date is. So I'm looking at, let's see. And I don't have the availability to check with my clerk because my criminal clerk is out this week.
Your Honor, we do.
So
I'm sorry, Judge. We do have other jury trials scheduled on your docket on July 9th. I don't know if that's too soon.
That's probably going to be. It's only a couple weeks away, so I don't know what his situation is, and even if he gets out in a week, that only gives him a little bit of time. I want to make sure he has at least a couple weeks to. I mean, it's a driving on a restricted license, so it's not exactly a whole lot of prep time for that. It's not a homicide case, but so I'm looking at August 13th. Because I'm trying to pick a date that's outside of probably where I'm already scheduling stuff at, because I don't have my criminal clerk here to kind of check and see like where I'm at with things. So we're gonna set this for August 13th.
Thank you, Your Honor.
And I know that we'll set that at 8:30 in the morning, August 13th. All right, Mr. Martin, let the deputy know that you're all set, and we'll be mailing out the notice to you, sir.
Thank you, Your Honor. All the best to you and your staff.
Say again?
That's something I want to say to with the prosecutors here. Dealing with this other case that I'm here for now, I request that
not the same prosecutor. Not the same prosecutor. That's the state prosecutor.
They're Taylor prosecutor.
Your other case, are you talking about your other case? Your other case is a state case. So that's a Wayne County Prosecutor's Office.
No, sir,
not the city attorney.
I'm talking about the case I'm in here now. I want to notify the prosecutor that I want charges filed on Crystal Martin for bringing these falsified charges against me now, and also for assault and battery that I have on video camera for. Just so, you know what I mean? And she keeps bringing this.
Again, that's the other prosecutor. That's a different prosecutor's officer.
Because it's my equal protection right to bring charges too. They want to bring charges against me, but they don't have no evidence. I do. And I should be the one suffering here in jail as a lack of evidence as a result of pride and the unequal protection clause.
And that's on your other case, sir. So,
it's still a right though. It's still my right to tell the prosecutors this and have them act on it. And if they don't, that's going to certify a defense.
This isn't the proper prosecutor. That's the Wayne County Prosecutor's Office on your other case, okay? This is the city attorney. Okay? Deputy, have a good rest of your day to you and your staff.
Thank you, Your Honor.
Thank you, Your Honor.
McMullen, case, the motion to set aside. Let me bring them out. People versus Martin, case 241388 SM. Today's the date and time set for a settlement conference. Also, there was a motion by Mr. Martin, motion to dismiss the case. Court has read through the motion. There was no accompanying brief in support. There's also objections to the denial of the personal bond. I'm going to consider that as a motion for reconsideration. All right, Mr. Martin, was there anything else you wanted to place on the record, sir?
Oh, yes. Well, first, I'm not the fraudulently assumed defendant. I am a living sovereign man.
I can see that you are a living man. You are currently talking and we are having a conversation, so, okay.
Right, but John, under the law, there's fraudulent presumptions under canon law 3228 that say otherwise, and there's a lot of support what I'm saying. That's why I say what I say to the record. But anyways, yes, I do have other things to say. First, I also want to file a demand to dismiss this case based on speedy trial violation under Michigan Court Rule 6.04C, 28 days for speedy trial in misdemeanor cases. I've been in jail over that since the 8th of last.
This is where legal theory meets factual record and loses. Speedy trial rules exist to protect defendants from unjustified delays, not to reward obstruction. Yes, Michigan law allows release after certain time thresholds, unless the defendant is deemed a flight risk. And flight risk isn't speculation. It's behavior. Repeated failures to appear. Open rejection of jurisdiction. Refusal to comply with court orders. Those aren't abstract concerns. They are textbook indicators that justify continued detention. And the judge lays that out clearly, on the record. What's powerful here is how the argument collapses under its own weight. You cannot simultaneously deny the court's authority and ask it to trust you. You cannot claim immunity from the system while demanding its protections. The law doesn't work that way, and never has. So here's the engagement question. Should speedy trial protections apply equally to defendants who actively undermine the process, or should cooperation matter? Because this ruling sends a clear message about where the court stands.
And also, go ahead and also say, I ask that you give me all the time to speak, say anything I want to say, instead of like shutting the court proceedings off that's happened before. Make sure I'm done with everything I have to say. But that's it for right now. But like I said, my to say depending on what you say in response. So.
All right, well, your motion to dismiss is denied. Your motion for reconsideration with regard to personal bond is also denied. Are we setting this for a bench trial or a jury trial?
Before I ask that question, I have to respond now to your denial. Now, based on what reasons are those denied, I have things to say in response to that.
Well, sir, I'm not cutting you off, but there's nothing, it's my ruling. If you want to file a motion for reconsideration as to anything, you're more than welcome to follow the court rule and do so. But there's really nothing to add to my ruling. I'm
asking the reason. I'm asking what are the reasons that the bond, for example, is denied? Okay, first of all, what reasons is it being denied?
I've already stated that last time, sir. So are we at the next question here is, do you want a bench trial or a jury trial?
Well, I have more to say in response to do
you want a bench trial or a jury trial, sir? Stop avoiding the question.
I just want to take off jury.
Jury trial. All right, we're going to set this for a jury trial.
But I want to make it clear, I'm not consenting to
you'll be given notice of when that will be, sir.
Okay, I'm not consenting to the jurisdiction of the court still, and
you are subject to the jurisdiction of this court, sir. You live in the state of Michigan, you live in the jurisdiction, and under the Michigan Constitution and the United States Constitution, this court does have jurisdiction over this case and over you as the alleged defendant. The warrant was signed with probable cause. The warrant had probable cause. The warrant was signed. That's all that's needed to bring a charge, and it's brought in the proper place, which is here because you live in Taylor, and this is Taylor, so this is where the case would be. So your motions were denied, and we're going to set this for a jury trial. We'll be giving you the date and time of when that jury trial will be. Let the deputy know that.
That's what I mean. See, I'm not done yet. I have more to say.
People versus Paul Kuhn, case number 235256.
Here, Coke on behalf of the people.
Kuhn is present here in the courtroom today. This was originally set as a sentencing hearing. Mr. Kuhn, I got a report from the probation department indicating that you declined to participate in the investigation process.
Up here for greetings, Your Honor. I'm here by special appearance, not a general appearance, and I reserve all my rights and explicit reservation without prejudice. I, Paul Kuhn, a sentinel moral being, have examined the path of my feet on and have concluded that I have dishonored many people, including but not limited to the people, the peace officers, the city, the county, and to determine that I have made many mistakes, and I'm sorry for my sins, and therefore I repent now. I have become aware of other sins I may have committed, and I'll repent immediately. To my attorney, it has come to my attention that you have never informed me of my choice of law, and to make matters worse, you chose an inferior form to have me tried under. You are either incompetent or collusive with the prosecutor. Either way, you have provided me with ineffective assistance of counsel, which has caused me great harm. You are fired.
Okay. Do you intend to hire another attorney? Are you appointed?
I was appointed.
How are you going to proceed in terms of counsel, Mr. Coon?
Oh, I'm gonna do it myself.
Okay. All right. You understand that you have the right to have an attorney?
I do.
And you understand that if you can't afford an attorney, you have the right to have one appointed for you at public expense, and in fact, that's what we've been operating under up till now.
I have got legal counsel, but anyways, I'll accept whatever you have.
Okay, so you understand that you do have the right to have an appointed attorney if you can't afford one?
I had him, and he has done me no good from the beginning. So,
Yep.
At this point, I'll just
I'm just asking whether you understand that you have that right.
yes.
And in spite of that, you're asking the court to allow you to represent yourself today?
Yes.
Okay. Have you ever represented yourself in court before?
Sir, I'm here as a special appearance only, and that's.
Yeah, that doesn't have any legal significance to me at all.
I understand.
My question is whether you've ever represented yourself in court before.
No.
Do you have any legal training or education?
No, just have the people that help me get through this.
Okay. And so you understand that there are, not having represented yourself, not having any legal training or experience, that there are risks involved in representing yourself?
Sure.
And that there are matters of procedure and substantive law that you may not be aware of, and therefore there may be arguments that you could raise in your own defense that might give you an improved outcome in your case, and that without that legal training and experience, you may not know what those are, and you may have a worse outcome than if you had an attorney.
I'll take what is given to me.
In spite of those risks, is it still your wish to represent
Yes,
yourself?
I'll take what is given to me.
That's not the answer to my question. My question is, do you still want to represent yourself knowing those risks?
Sir, I just I'll accept any offer. In return, your offer to your, for your closure and settlement of any account I may have.
Okay, again, my question is, in spite of the risks of representing yourself, are you still asking to represent yourself?
Yes.
All right. So at this point, the court, with Mr. Germerty, will discharge you. The court finds that your request to represent yourself is knowing and voluntary and unequivocal. And so at this point, the court's going to allow you to represent yourself going forward. Do you have anything to say with regard to your refusal to participate in the pre-sentence interview process?
Whatever you want to give me, I'll accept.
Okay, so that's something that you're required to do as part of the court's order. Because you declined to do that, the court is going to revoke your bond. The court is going to order that you be remanded to the Crawford County Jail. I'm going to request the probation officer to make another attempt to go through the pre-sentence interview process with you. If you continue to decline, then we'll just go forward with sentencing without having that information before the court. And Mr. Haven, if Mr. Kuhn refuses to participate, you can just indicate that for the court and then prepare the pre-sentence report to the best of your ability without that information.
Yes, sir.
I did an acceptance, dated and signed the top of it. And that's all I'm doing.
Okay, well, we'll give it another try anyway, and you're going to do what you're going to do. But for today's purposes, the court's going to revoke your bond and remand you to the jail. The court will set this for a sentencing hearing at its next available date. Okay, so I just want to explain a couple things to you. I have an obligation to ask you certain questions to make sure that you understand what's happening with your case. And that's why I'm asking you whether you understand that you have the right to have an attorney and that you would have the right to have one appointed if you couldn't afford one. I'm just trying to make sure that you understand your rights, and it's my job to explain those rights to you. I'm not asking you to give up any rights. You're not putting yourself in any kind of legal danger by answering these questions. I'm just trying to find out if you understand what your rights are and how we're going forward, so that I know that you're knowingly and voluntarily choosing not to have an attorney to represent you. And if you don't answer these questions that I'm asking you, it impedes my ability to proceed with the hearing in the way that I'm required to under the law. Do you understand that?
How to answer that? All I know is I was told, when I've read and stuff, that I'm here in special appearance.
What do you think that means?
I'm not contracting. If there's no corpus electi, how could there be a crime?
Do you know what that even means?
There's no injured party.
What you're saying?
If there's no injured party, where is the crime?
Okay, well, first of all, a jury found you guilty, right?
And that, I'm stepping
And they
into
found you guilty of assaulting, resisting, or obstructing two police officers. Right? That's what happened.
I'm here on special appearance.
Okay. If you continue to refuse to answer my very simple questions just about whether you understand what's happening, and if you continue to just give me that answer, which doesn't make any sense and doesn't have any legal effect, no matter what you've read or what other people have told you, then you're impeding my ability to proceed in the way that I need to under the law. And if you continue to do that, my only option is to impose a sanction on you until you do answer my questions. And what that means is that I'm going to find you in direct contempt for impeding the function of the court by refusing to answer very simple questions. And I'm going to put you in jail for 30 days. And if at any point during that jail stay, you decide that you will answer these very simple questions, then we'll come back into court immediately and we'll take care of the sentencing. But those are going to be your options, because I'm not gonna have you just.
Okay, well, thank you.
So it's your choice. You can answer my questions, or you can
an attorney, but the attorney I had absolutely did nothing.
Okay, we're past that point. What we're here for today is a sentencing hearing, because you've been convicted, you've been found guilty by a jury of your peers. And so we're here for sentencing. So we're not here to talk about what did or didn't happen with your lawyer before. I'm trying to find out if you understand that you have the right to hire your own lawyer, or if you can't afford one, that one will be appointed for you. Do you understand that you have that right?
Yes.
Okay. And you understand that proceeding without a lawyer has certain risks. Do you understand that?
But I obviously can't afford an attorney.
Okay.
And the one I had, again, didn't do a dang thing because the ticket should have never been split.
Okay. Do you want to
That was my
request?
argument to begin with.
Do you want to request a different attorney to be appointed?
Actually, yes.
You did. Okay. All right. So you did previously qualify. So I find that you continue to qualify for court appointment. Court is going to appoint one for you, and we'll reset this hearing for my next available date. Okay.
Am I going back to jail or can I go home?
No, you're going back to jail until we can have the hearing.
I've already had 3 weeks in jail, sir.
And you made that choice by refusing to comply with the pre-sentence process. That was your choice. You're just facing the consequences. People advising you to take this ridiculous stand and make these statements that don't mean anything to the court, they're giving you really bad advice. And they're not the ones paying for that advice, you are. And I think you need to start listening to a lawyer who actually knows something about the law and not what you read on the internet or what people tell you because they don't know. And you're taking their advice and you're paying the consequence for their bad advice. They're out doing what they want to do. You're the one who's in here in jail. So I would suggest that you start listening to a real lawyer and not what you read on the internet or what people are telling you who really don't know what they're talking about. So that's the way we're going to proceed. We'll appoint an attorney to represent you at the next hearing. And your bond is going to continue to be revoked until that time. What's that?
And when will that be?
When you step back and look at the full picture, this case isn't about conspiracy, corruption, or hidden law. It's about choices and consequences. Across multiple hearings, the court consistently offered structure, procedure, and opportunity. And each time, those offers were met with defiance instead of engagement. The judge's rulings were not personal. They were procedural. Jurisdiction was established. Probable cause was documented. Bond decisions were explained. And repeated refusals to cooperate directly resulted in continued custody. That's not punishment for beliefs. It's accountability for conduct. The broader implication is clear. Sovereign citizen arguments don't collapse the system. They collapse the defense using them. Courts are built to withstand rhetoric, but they respond decisively to behavior. Now I want to hear from you. Who do you think handled this situation correctly? Where do you think things went wrong? And could this outcome have been avoided? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. Stay tuned, because these cases are far from over.